So welcome everyone. Hello to today's webinar. We'll be discussing the top 10 legal mistakes business owners make and how to avoid them. I can already see that we've got a few participants, but just until we wait for everyone to join, I'll send you guys a poll and you guys are more than welcome to answer it. And then once everyone is here, we'll begin the presentation. So I'll send you guys a poll. So just feel free to answer those and then we'll get started. Okay, so we can see a good mix of the company's biggest focus in 2022. It seems to be sales and marketing, talent and hiring coming close second. We have a lot of people here from consulting, which is interesting. Awesome. And then as a business owner, what has been your biggest challenge to date? Marketing and branding. Okay, very interesting for those who want to know. Starting a business. Well, it's great that you guys are here today since we're going to go over that. It's also great to see that COVID-19 hasn't really affected anyone, which is fantastic, given that it took over 2 years of many businesses. Awesome, really great results. Okay, we'll just give it a few more minutes. And then we'll begin in 2 minutes. So just keep answering those questions. Hope everyone had something to eat, given it's already 12 o'clock. Awesome. So just the sound check as well, if you guys could just put a thumbs up in the chat if everything's all good, if you guys can hear us well. So the session runs for 1 hour. And towards the end of the session, we'll be doing a Q&A. Awesome. Thank you, everyone. Fantastic. Okay, we'll kick things off. So let's just go to the next slide. So welcome everyone. My name is Angela, and I'll just go through some housekeeping before I pass it on to Damin. So throughout the webinar, Damin will be running through some content, but feel free, if you had any questions, to pop it in the Q&A section down the bottom. If you can, please don't put it in the chat because as you guys can see, it can easily get lost. So if you do have any questions, just pop it there and Damin will endeavor to answer those at the end of the webinar. So today's agenda is we're going to go through about who we are and Damin will give a bit of an introduction about himself. Then we'll move on to the top 10 issues most businesses face and how to avoid them. And Damin will be providing a high overview of the different issues. We'll also go over our legal health check, but again, towards the end of the webinar, you'll know what that's about. And we'll also have a special offer for our attendees today. So let's move on. So for those who have joined our webinar before, welcome. For those who are brand new, welcome as well. You may not know what Lawpath is about, but I just wanted to give you guys a bit of an overview about who we are. So essentially, Lawpath is a platform for all your business and legal needs. It is designed to provide all the tools that you need from the legal side of things. So what we offer is over 350 legal documents and business documents covering areas such as employment, confidentiality, intellectual property, business contracts, and website compliance. You can sign documents online using our e-signature tool, as well as hiring a lawyer online for a fixed fee, or booking consultations with your lawyer as well. We do have on-demand legal calls with a lawyer plus accountant to discuss your legal matters. And also you have the opportunity to register your company ABN or business name. So I'll pass it over to Damin, who will be going through our presentation today. But again, if you do have any questions throughout the webinar, please feel free to add it to the Q&A, and we'll go through those questions right at the end. Thank you.
Hi, everybody. My name is Damin Murdock. I am the Legal Practice Director of Lawpath Legal, which is a wholly owned law firm owned by Lawpath, kind of internal and add-on to the Lawpath platform. Being a lawyer for more than 13 years, I've acted in almost every state court, from magistrates, local courts, Supreme Courts, you name it. I've had my own law firm in Sydney and in Melbourne, and I've run a law firm up in Brisbane as well. So I'm across most of the state laws as well. We do a little bit of work out of Western Australia, a little bit in Tassie, a little bit of South Australia. So some of the law slightly changes between the states. So it'd be good if you do ask a question, just let me know what state you're in, because it might be relevant. Just remember that we're not answering any questions in the chat group. So if you want me to ask or answer any questions, make sure you put it into the Q&A tab as opposed to chat. And if you already put your question in the chat, put it into the Q&A. I do like to try to answer questions as we go. So ideally, if I can see them pop up, then I will try to answer them. Otherwise, we will answer them at the end. So the first thing that we like to start off with is naming your company. You're creating a brand, you're doing your marketing, you're doing your advertising. A lot of people said the biggest thing that they have, or the biggest hurdle, is actually getting sales, doing the marketing, doing the branding, doing the sales. And one thing that people really make a mistake on is naming their company at the beginning and not realizing that there's another company that has the exact same name. So a lot of people will think that because they've registered a business name, they now have that name. That's incorrect. You can register a business name, ABC, and someone else can just register another business name called ABC Holdings, ABC Enterprise, ABC Group, you name it. So getting a business name, all that does is stops another company having an identical name. What actually protects your brand is a trademark. And so what you want to do is before you start trading your business, you want to make sure that you're not going to be stealing someone else's brand or copying their brand or using the same name as them that's going to be misleading or deceptively similar. And the main concern for that is if they've been using that brand longer than you have, they could go and register a trademark. And then in 3 years from now, after you've developed a brand, you get a letter from a lawyer saying you're infringing upon their trademark. So there's a couple good searches that you can do just to make sure that your name is fairly original and it's not going to be infringing upon someone else's trademark. So you can go to ASIC, you can go to ABN lookup. So if you just Google ABN lookup, or if you go to the ASIC Connect website, or you go to GoDaddy domain name search, or just Google around, we always recommend you do that at the beginning. Here's some links. If you look at the ASIC Connect link, when it says within, you just go to the drop-down box and you type, you go to organizations and businesses, and then you just type in the name of your company, and then it'll show up with all the different companies that have a similar name. And in relation to trademark search, same thing. You can go have a look, see if anybody else has a trademark that is the same or similar to your trademark. Now, there's two ways to search a trademark. You can do a quick search where it's just a box and you type in the word. So if your business is called, Lawpath, and you type in Lawpath, probably nothing else is going to come up other than Lawpath, which is this one. But if you spell it different, like with a T or an A or an E, it's not going to pop up in the quick search. So what you should look into doing is when you go to do a trademark search, go to the advanced option. And if you have the word ability, maybe you want to start with able and then see if who else has the ility as a separate. So just a couple hints about trying to find other companies that have similar names that might be spelled different and Googling around, obviously. Now, so that's the first thing we find that most people make a mistake on. The second thing is a non-disclosure agreement. It's fairly generic. When I talk about non-disclosure agreements, it's more of it comes into a more bigger play because a non-disclosure agreement is a standalone agreement. Sometimes it's enforceable, sometimes it's not. It depends on the facts and the matters and the circumstances of what you're doing. You can't protect an idea. So if you say, I have an idea of doing this, you can't protect it. It has to be your whole strategy, your plan, your actual copyright. So if you've done a drawing or if you've done a layout or particulars or anything like that, or a website, that is protected by copyright automatically. But just an idea that's not written down anywhere and that hasn't been implemented in any way is generally not protected. So Lawpath does have a general non-disclosure agreement. If you are going to talk to people about your business, consider getting one. But it's definitely important when you're hiring people and having a confidentiality clause within every one of your agreements. So if it's a contractor's agreement, employment contract, you name it, you always want to have a confidentiality clause within it. But with a non-disclosure agreement, that's basically your preliminary discussions. It's good to have one. Whether you can enforce it will depend on whether your idea is mature enough and whether you actually have something that's available to be protected. So again, Lawpath has all these documents, 350 of them. One of them is a non-disclosure agreement. They have one-way ones where you're disclosing the information. They have mutual ones where you're both disclosing information. And if you're new to Lawpath, they also have contractors agreements, employment contracts, subcontractors agreements, consultancy agreements, terms and conditions with your clients, and so on. Now, the main dispute or the main issue we find is that 3 people will go in and they will decide that they're going to go in and start a business. And it might be the CTO, it might be a CEO, and it might be a COO. So someone's head of the operations, someone's head of the technology, and someone's going to run the main aspects of the business. Now, at the beginning, they don't have any tech. So maybe the CTO quits his or her job and starts building the technology. And then the CEO and the COO say, well, okay, well, once the tech's ready, we'll jump in and we'll quit our jobs too, and we'll all go in together. But maybe that technology takes longer and that CTO is still not taking any income while the other founders are taking an income. Or maybe it's a situation where it takes so long to launch that one of the people lose interest in it. Now, what happens there is if you have already started your company and you each have 33% shares, and someone quits or resigns or doesn't come and join the business full time like they promised, what do you do? If you have given 33% shares in your business to that person with no strings attached, then you're in trouble because you've just given away 30% of your business without any strings attached. And so that's why we normally talk about vesting conditions and making sure that if anybody is going to be getting shares in your business for providing future services, they should always be connected to what's called vesting conditions, which means they actually have to earn them. They can have them now, but they still have to earn them. And if they don't, you can buy them back. And I'll get into vesting conditions later. But another thing to look at is just whether everybody's on the same page. You know, if you want to get a loan, you need to have a business plan. If you want to start your business and you're going to get some money from an investor, you normally want to have a business plan. And a lot of people forget about actually doing a real business plan, or a lot of times people will do a business plan purely just because it's a tick of a box. But the reality is it's really, really important to have one to make sure you and your business partner and your investors are all on the same page. Because if you don't, it could lead to a dispute later, and it could stop exactly what you're trying to achieve. So make sure you get a business plan, get a budget done as well, so that you know if you're going to have money, how you're going to use that money, and exactly have an agreement in advance of that money even going in, how it's going to be used. Now, a good example is this guy. No one knows who he is. I looked up his net worth today. He's worth 1.2 million. So he's 76 years old. He has $1.2 million worth of assets, which is great. Unfortunately, though, he founded Apple, and he could have been worth, well, here it says 45 billion, but today I did another look and it said up to 95 billion. And what happened was that this guy's gone in as a co-founder of Apple. He put money into the company, and then he didn't like the fact that Steve Jobs was going to go and raise some money by way of debt. And because he had put money in as a shareholder, he was concerned that by raising debt, if they weren't able to pay that debt, then he could lose his shares. And he got in a big, huge fight. So as a result of that, he went and sold his shares for $800. And that's unfortunately his history, which is he co-founded Apple, got in a fight because of how the money that was going to be used, and sold his shares. And unfortunately for him, he lost out on billions and billions of dollars. But that's just a really good example of making sure you're on the right page. If you're going to be an investor, you're going to invest into someone, make sure you know what the terms are. How is that going to be used? A lot of times people will say for the normal business purposes, well, that's not really good enough. If I'm going to give you $50,000, I want to know, what are you going to spend it on? Are you going to use it to pay your own wage? Well, if you're going to use it to pay your own wage, then you're probably not going to get an early stage investor, because the investors normally want you to work for free on a shoestring, because they want you to earn your shares yourself and put something into it. And so if someone's going to put money into it, they expect you to put time into it. And what's important is making sure that if you're going to take in money, you spell out exactly what that money is going to be used for. And if you have a business partner, you spell out exactly how much money you need, how is it going to be spent, and what the conditions are, and how much do you need, and when are you going to do a new raise, and what are your thresholds in terms of how many users do you need, what revenue do you need to pay back a loan, things like that. And it's all about communication and brainstorming and really thinking this through if you're just getting your business started. Now, I'm talking a little bit about startups and business and just getting going. Let me know whether you are 5-year advanced company or 2-year advanced company. You can put that into the chat, just so that if there's no one here that's actually a fresh startup, then there's no point in me talking about some of the basics. Or we can have a look at the polls. Let's see. Oh, Angela will help me here. Oh. Anyway, I was just going to have a look at the polls and see what the results were, just to make sure. I suspect that most of us are pretty young. So 38% of the companies are less than a year, and 50% of the companies are less than 2 years. So we're at about 50-50, less than 2 years, 50%, and then the other 50% is above that. All right, so that's just an example of this guy. Now, in Lawpath, we have a bunch of different documents. So I'll just briefly talk about the capital raise. If you're looking to expand now, how do you take in money? What document do you use? What's the process? And what do you need to make sure you cover? So the first thing is that normally, if you're raising money, it's by way of you selling shares in your business. So if you're selling shares in your business, you need 2 primary documents. The first one is called a subscription agreement. And a subscription agreement is a document that is essentially saying they're going to put in $50,000 into your business in exchange for you issuing shares to the value of $50,000. And then you normally give a bunch of different warranties, like you're allowed to issue these shares. No one's suing you. You don't have any big debts. You don't have any long-term liabilities. If you show them the bank statements, those are true and correct. And that is the document that deals with of actually issuing the shares, and it spells out all the different steps involved as well. So you'll issue share certificates, you'll notify ASIC, you'll update your share register once you receive the money. And then the other documents, the shareholders agreement. A lot of times people call them partnership agreements, but that's incorrect. A partnership agreement, partnership is actually a totally different entity. If you have a company, it's a company. If you're a sole trader, you're a sole trader. If you're a partnership, you're a partnership. So when you actually have shareholders in your company, it's not a partnership agreement you're looking for, it's what's called a shareholders agreement. And so the main way is you sell shares. Now, you can do different capital raises as well. So you sell shares by way of a subscription agreement, or alternatively, you can also do what's called a convertible note. And a convertible note is essentially saying the investor is going to lend you $50,000. And at the end of 2 years, that lender gets to decide whether to pay you back the 50 or whether to get paid back the 50,000 plus interest, or to convert that 50,000 into shares. I don't like convertible notes. I don't think they're very good for a startup, and I don't think they're very good for any company at all, but they're very good for the investor. And the reason why they're not good for a startup is because if an investor gives you $50,000 now, and in 2 years from now, they decide that they don't want to actually convert their money into shares, then what that means is they're actually not interested in your business and don't think you're growing fast enough and not good enough to be actually invested into. And so that means you now have to pay back the 50. But can you actually pay back the 50? And the reality is normally not. If the investor doesn't want to buy shares in your business, it's because your business isn't as successful as the investor thought it was going to be. So now you have a debt that's due that you can't pay back, and effectively you become insolvent. So convertible notes are extremely dangerous. I don't recommend them because they can result in your startup going into insolvency because of the investor simply deciding to not to convert their money into shares, but instead to ask for their money back. If you want to have a look at what the normal document looks like when you start talking to an investor, you can have a look at the document called a term sheet. A term sheet spells out normally what the documents will say before you go to a lawyer. It's a high-level discussion about, all right, so we're going to invest this much money. Your business is valued at that. And then you can put your brief in and you can ask, well, I need a lawyer to help me draft this document. We will then we'll put a quote in and say, we'll draft this for you. And then in that circumstance, if we're hired separately as a law firm, then we do supply the documents, but that's normally a paid service. We also have what's called the legal advice plan, which is you can pay an annual subscription and you get unlimited phone calls with lawyers from Lawpath Legal. In that circumstance, you have unlimited 30-minute phone calls on any new legal issue with us, the lawyers. And in that case, we review the documents that you have. So either documents that have been provided to you by your client or a law path that you're preparing from the Lawpath documents. You're starting up a startup. and you want to set up a trust for a company, which is the best way to set that up? So there's 3 different kinds of trust generally. There's one called a discretionary trust, there's one called a unit trust, and there's one called a hybrid, which is a mix between the two. Most people go with the family trust. The family trust, discretionary trust, essentially the way you set it up is you have essentially 4 positions. You have a settler, which is the lawyer or the accountant that sets it up for you. You have the appointer, which is the person that's in charge of it, ultimately in control of it. And that appointer appoints the trustee. The trustee is the decision maker who makes the decisions on how the money is to be distributed, signs all the documents for you. And then you have the beneficiaries, and those beneficiaries are the ones that are going to receive the distributions that come into a trust. Normally the structure is you incorporate a brand new company, and when you incorporate that brand new company and ask who the shareholders are, you say the shareholder is the trustee holding it for the benefit of the trust. And that's as easy as you do it. You need to have a trust, obviously, but that's essentially it. We normally don't do unit trusts. Unit trusts are normally very good for property investors who have put in money, and for each unit you put in, or each dollar you put into a unit trust, you get 1 unit. And normally that's used for a much larger investment purposes, but for small business, it's normally discretionary family trusts. What's the difference between a confidentiality agreement and a non-disclosure agreement? Nothing. It's the same thing. What's the difference between a consultancy agreement and a contractor's agreement and a supplier contract? It's just named something different. Primarily, it's going to be the same thing. I guess the non-disclosure agreement is normally saying you're receiving information, so it's a one-sided. Oftentimes you're receiving information and you must not disclose it, and you must not use it for any purpose that is not specified in the agreement, whereas the confidentiality agreement is an overarching, everything that's given to us is confidential and must not be used. You normally have a confidentiality agreement with employees, whereas a non-disclosure agreement oftentimes you use for investors, because it says that they can actually disclose under certain circumstances, whereas with an employee, they're never allowed to actually disclose the confidential information. How do you turn your business into a shareholder system? So essentially, if you're a sole trader, you would normally sell all your assets from you yourself into a new PTY Ltd company, or alternatively, you would transfer your assets from you into your brand new company. In exchange for that, you get shares in the company. So it's a fairly easy process. But administratively, it can be a little bit difficult because you got to change your bank account details, you got to get a new ABN, and then you got to understand how companies operate and what's involved in the Corporations Act. And there's lots of resources on the Lawpath platform that can explain all that to you about how that works. There's a lot of these videos as well that you can watch. But it's a fairly simple process. If you have an accountant, they can do it for you, or you can even call Lawpath, their number on their website, and they can walk you through that process as well. Do we have any long terms, or can you agree to longer terms on a convertible note, i.e. you pay back in 5 years? You certainly can. You can have that, but again, the situation really is even if you agree to pay back in 5 years, in that circumstance, it actually might not be good for the company, because, for instance, what happens is when you do a convertible note, there's certain definitions. One is the maturity date, so you can put 5 years, and the second one is a valuation cap normally that says that we will convert our shares at a maximum value of, let's say, $1 million. So if you have a maturity date that's 5 years from now, which is great because you don't have to pay back that investment for 5 years, But the negative part is that they get locked in at the valuation at the time that convertible note came into existence. So they get to convert their shares at $1 million valuation in circumstances where the company in 5 years' time might be worth 10 million, for instance. So that's essentially it. Now, on terms of copying, pasting online terms and conditions from other websites, look, well, one is copyright infringement. If you're taking someone else's terms and you're cutting and pasting it and then using it, there could potentially be a claim against you for copyright infringement. And that's because you've stolen someone's terms. However, a lot of terms and conditions are actually based from lawyers, and a lot of the lawyers have got it from somewhere else as well. And a lot of the terms have been drafted many years ago, and they mismatched all over the place. So it's very hard to have actual terms and conditions that are 100% or substantially original. And the reason for that is that the lawyers have been using terms that have been around for a long time and that have stood up in court in the past. But what is really important, though, is if you are taking someone else's terms, one is you definitely need to reword it, and you definitely need to make sure you're not going to get caught for copyright infringement. So it can't be a copy in substantial form. But second of all, if you're going to take someone else's terms and conditions, you need to make sure they're actually going to work for your business. And you'll know whether they work for your business is because you'll start having some pain points, or people aren't paying you on time. People are disputing about what is included and what's not included in the services that you're offering or the goods that you're selling. You might have warranty claim issues. You might have delivery issues. You might have chargebacks from credit cards. And so that's where you really need to start tailoring up your terms. So if you want to go low cost, you just need to get your business off the ground. Best bet is just grab one of the website terms and conditions for websites on Lawpath's platform. I actually drafted them several years ago. One's in relation to goods, one's in relation to services, one's in relation to software as a service. Some have delivery terms and so on, payment gateway terms like Stripe and things like that. So I would start with those, but make sure that you start tailoring them to suit your needs when you start finding that there are issues with those terms. And that's the biggest thing that we find is people don't have proper terms and conditions. And that's where they start having the pain points of bad debts, disputes, people wanting refunds, people having chargebacks and so on. So terms and conditions of your business is probably one of the biggest things that you should really focus on and make sure you get it right. We also have a privacy policy. A lot of people as a startup, you're outsourcing work to other contractors because you can't afford to pay for an employee right now on a salary. Well, if you're transferring someone's personal information over to a contractor, you're in breach of the privacy principles of Australia if you have not got consent to do that. And the way that you can get consent to do that is one, having in your terms and conditions the right to subcontract, and secondly, having a privacy policy that says that you will share their personal information with third parties for the performance of the services that you're offering. GDPR is if you're going to do business in Europe, in the EU, you need to have one of those. And that's about it, really. Privacy policy, GDPR if you're in Europe, NDA if you're going to be talking to third parties, or confidentiality agreement. And that's essentially the bare bone basics to protect your business, and definitely situations where having a shareholders agreement is really, really important. Now, when you look at terms and conditions there, I guess the question is, what are they? A lot of times people might have a proposal that they offer to clients, but they actually don't have the terms. And in essence, the terms are normally saying how a proposal is accepted, or how it's, so is it you're clicking to accept the terms, or are you implying, or implication, you're accepting by implication by continuing to instruct me. So A lot of recruiters will send terms and conditions by email. Those terms and conditions have a clause that says, by you sending us a CV, or by you sending us a job description, or by you continuing to instruct us to act for you, you agree to our terms. And that's acceptance by implication, which is fair as long as those terms are given to the person and the person is notified about that. So it deals with the offer acceptance, standard contractual relationship. But the main thing is limiting your liability. Under Australian consumer law, you can't say I'm not liable for anything, but you can limit your liability. And you can say, well, if I did breach something, then the most that I'm liable to you for is to pay you back for the services or for the fees that you've paid me. And that's it. And if you don't have that in your contract, then your liability is endless potentially. And that's because of Australian consumer laws says that there's certain guarantees. If it's a guarantee for goods, it's of merchantable quality. It's similar to the description. If it's services, it's going to be performed within a reasonable period of time. And there's a whole slew of different guarantees. And if you breach those guarantees, you can be sued for damages. And that's the loss and damage sustained by your customer. Now, if you haven't limited your liability, that loss and damage can be quite significant as long as it's not too remote. But it can be potentially loss of future earnings, loss of opportunity, loss of chance, loss of contracts, things like that. So terms and conditions are primarily limiting your liability, making sure everybody knows what the remedy is if there is a breach, how you terminate your customer, what your refund policy is, how people accept and reject changes, and what your pricing is and how you amend your pricing. Force majeure during COVID was a big thing, people needing to get extra time because of the pandemic, or people need to change venues or change dates, things like that. You need to have those in your terms if you're going to be able to change what was originally offered to somebody. Now, intellectual property, I've been doing a lot of capital raises recently, closing a lot of deals. The investors are quite eager at the moment, putting a fair amount of money into a lot of different startups. And the number one thing that I've been coming across is open source code. People using that in their technology and not realizing that there's actually certain licenses attached to open source code. So I think the main license you want to be looking for is MIT, and MIT is basically an unlimited license. But then there's other licenses that require you to, if you build upon an open source code, you have to upload anything that you built and also make that open source as well. And if that's what you've done, no investor will invest into you because you actually don't own your IP. And that's when it comes down to managing your intellectual property. So number one is every investor I've dealt with and the lawyers for those investors I've dealt with in the last couple of months, they want to make sure that the IP is owned by the client going back to day one when that company started. The logo, the very beginning of the design, the name, the website, everything involved with that company from start to finish. So if you've gone to Fiverr, if you've gone to any freelancer or anything like that, and you've got any intellectual property developed by anybody who is a third-party contractor, you need to make sure that you have a contract and it says that you own the intellectual property that they've developed for you. And if you haven't done that, then you should go and get an IP assignment deed now and go back to them and ask them to sign off on that for you, because in 5 years from now, investors, they may invest into you, but the condition will be that you personally give a full indemnity to them, that if a contractor comes up in the future and says they own that IP, then you will forfeit all your shares to satisfy that investor for breaching that warranty. And I think that's the thing that you see a lot, in the sense that there are a lot of people who are working their day job, and then they are also building their own platform or building their own business, potentially using their employer's computer and potentially during an employer's time, 9 to 5. Especially with people working from home, a lot of people are in a position where they're working on their own little thing outside or during office hours at home. Now, if an employer finds out about that, and if you were to go and resign from your business and then go and start up your new one, there might be a situation where it's actually your employer that owns everything that you've developed. And the reason is twofold. One, by way of common law, just past cases, if an employee uses the employer's resources to create intellectual property, that intellectual property is owned by the employer. Number two, you also have probably a contract, an employment contract, and you probably have a clause that says any intellectual property that's brought into existence or created by you during your employment is owned by the employer. And so there is a possibility that you quit your job, go start a new platform, becomes very successful. Your old employer could come after you and sue you for that intellectual property. And this is another thing that was similar in the Zuckerberg case. You had the Winklevoss twins. They came up with Facebook. They came up with the idea. They went and then hired Zuckerberg. They didn't have a contract in place. They didn't have a contract with Zuckerberg that Zuckerberg, anything he develops for the Winklevoss brothers is owned by them. So Zuckerberg, because he didn't have a contract, he took the idea and he went and started Facebook and made billions. And so this is another reason why you really want to focus on your intellectual property, making sure that you have a contractor's agreement. That contractor's agreement normally will have a confidentiality clause, an intellectual property clause, and normally a non-solicitation clause where people aren't going to steal your employees, contractors, or clients for themselves. So number 6 is incorporating your company at the wrong time. So there's nothing wrong with starting out as a sole trader. And a lot of businesses here are probably sole traders. And there's a lot of time, there's no point of actually having a company at all because you haven't even got it off the ground. And you don't need to create a company and incur all the costs of creating that company and then winding it down, incurring the cost of winding it down. But the problem is sometimes if what you're actually doing is developing software, I know I've been talking about software a lot, but that's what a lot of the startups are. They're in that space. But if you're not a software company, I'm sorry, I'll try to tailor it a little bit more for you. But in the sense that there's the research and development tax incentive. So the research and development tax incentive applies to anyone who's doing research and development and is an incorporated company. They can get 43.5 cents back on the dollar that's spent on their R&D. So if you're about to build a bunch of software, you can do it in your own name as a sole trader, not keeping any timesheets at all, and get nothing back from the government. Or you can incorporate a company. You can put yourself, even though you are a founder of the business, you can put yourself on as a contractor to the business. You can keep a timesheet of the time that you're spending on building your business and doing research and development, possibly marketing, whatever it might be. But if it's R&D related, and then you can put a claim in to the government at the end of the year, and they will literally pay you money. It's not a credit. It's not offsetting the tax you owe. They pay you that money. So a lot of people don't know that. And as a result of not knowing that, they haven't actually created their company on time. Another thing that people do is if they're trading their business, they maybe they should have a holding company. So they might have a very high risk industry where they've developed a bunch of intellectual property, and then that company is the one that's trading, and then they get sued and lose everything. But all they needed to do is create a holding company, license that intellectual property to the trading company. And if that trading company got sued, you can just gut all the IP that's held by it, pull it back up to your holding company, close down your trading company, start up a new one, and your whole business would have been saved purely because of the way you structured your business. But in short, having a company, it is valuable because you have limited liability. You're limited to the amount you've paid on your shares. and you're entering the contracts on behalf of the company, not you personally. Now, I talked about before issuing shares without vesting conditions. And this is just an example. You both start a business, 6 months later, someone wants to move on. You've already given shares. If you've already given the shares, there's nothing you can do to get them back. So there's something called reverse vesting. You give shares to someone now, you have a shareholders agreement in place. That shareholders agreement says you have to work in the business for 4 years, which is 48 months. And for every month that you work in the business, you slowly earn 1 divided by 48 of your shares. And so if someone was to quit after 24 months, they would be entitled to keep 24 divided by 48 of what they earned, and they would lose 24 divided by 48, which is the other half, because they haven't earned them, and the company has the right to buy them back for $1. A lot of people will use the 1-year cliff when you're talking about, that's called reverse vesting. The other way is to offer it to employees, and sometimes it says that you can have shares, but you're not eligible to start vesting, and those shares don't vest for 12 months or something like that, and then they start being earned. One of the things that a lot of people struggle with is starting your business and having no one to talk to. And it can be very lonely as a founder, working 18-hour days or 12-hour days and having no one that you can lean on and talk to get idea, get guidance. And we always recommend as a founder, where it can be a lonely place, to look for advisors. Could be your parents, could be an uncle, aunt, could be some old colleague, just someone that you can lean on and talk to and think out your business and think about what you're offering and get some ideas. And it's a great way to build your business as well, because if they become involved, then they're going to promote your business as well. And they might be able to do some sales for you potentially just by talking about your business at a coffee or a lunch. And I'm just trying to rush through a little bit so we can get to the actual questions. I've kind of touched upon hiring people without proper contracts in place. The main thing is for employees, and the main thing to consider is having proper termination clauses, serious misconduct. So if you have a serious misconduct, or if you just have an employee that requires a driver's license, putting into the contract, you must have a driver's license. If you don't, we can terminate you without any notice. The Lawpath, and then also considering about the notice period that you're putting into the termination period. So is it 4 weeks? That's fine, but if you need to terminate someone, you've got to pay out the 4 weeks. Or is it in accordance with the Fair Work Act, which is a schedule that has a table in section 117. So just having a look at the employment contract and making sure that it works for you is also important, and making sure that you pay very close attention to the job description of what they're going to be actually doing and the termination clauses, and making sure that they're agreeing to any past and future policies and procedures or handbooks that you might have in the future. Now we'll get into the legal health check. So Angela will jump in and explain to you about that a little bit.
I don't know if you guys can see me, but yeah, so as Damin mentioned, we recently launched our legal health check. So what this essentially is that it will, it's a cost-effective way for you guys to take a questionnaire, and I'll be sending the link for you guys to give it a go, and it will give you a personalized report that will generate essentially the legal gaps in your business. So we'll cover things like employment, intellectual property, as Damin mentioned, hiring, your marketing strategy, where you're missing. So it only takes 5 minutes to complete the questionnaire, and it's just a really, really great way to see where you can actually solve, I guess, legal gaps in your business. So it's as simple as the first step is to complete the interactive questionnaire in less than 5 minutes. Once you add your email and your name, we'll send you guys a personalized report for you to review. And then you can discuss your results for free with our consultants and see what areas you can get additional assistance with. So I'll be sending this link in the chat box. And another great thing is if you do complete it, we do have a special offer, but we'll go through that right at the end as well. So back to you, Damon.
All right, thanks. Now, another thing is using the wrong lawyer. I know that might sound terrible, but I'm a panel lawyer for the Master Builders Association, for instance, and all I do, well, a lot of what I do for the Master Builders is advising home building builders on legal matters. Now, I know those legislations inside and out, and I know a lot of the cases that exist as well. And so if a client comes to me, I can normally answer that question, and I can normally do that work in a couple hours because I've done it 50 times, for instance. Whereas if you went to a suburban law firm that doesn't do that, they might first charge you for a letter of advice to get advice on, to research how to do it. And they also might hire a barrister to get a second opinion. And I've seen cases where I charge $850 for, and I've seen some clients being charged $7,000 for the same thing. And that's just because it was the answer. I knew exactly what case law it was. I knew what section of the act it was. Whereas that law firm that doesn't do that, they ended up having to go and research it and get independent advice from a barrister and so on. So one of the things is look at what your business does and try to find a lawyer that knows what your business does, knows your industry, because if you do end up hiring a lawyer, you want to make sure that they have experience in that field and know how to do it. So one of the things about the lawyers on Lawpath marketplace we are generally startup friendly, and I'm closing out a 10 million US deal right now for capital raising. I just closed a 5 million one not too long, a couple of weeks ago. We have another one where we've just done an acquisition of mortgage brokerage company. And so we do capital raising all the time. We do corporate structuring, establishing trusts, creating shareholders agreements. And that's what we call corporate law. And so even though it's startup law, that's corporate law. And if you hire a lawyer, you need to make sure that lawyer knows the Corporations Act very well and the ASIC Act, so the Australian Security Investment Commission, making sure that in terms of financial products and financial services, because a share is a financial product, and knowing the exemptions that exist and things like that. So just to give you an idea of fees, and we've had over 15,000 jobs through the Lawpath marketplace. So not just Lawpath Legal, the law firm does the work. You can go to the marketplace and ask Lawpath, I want a family, or not a family lawyer, but I want a lawyer that specializes in this area in my hometown. And Lawpath has a marketplace with lawyers all across Australia that they can connect you to and get that lawyer to give you a fixed fee quote. And this is just a general overview of the general pricing that Lawpath has seen in terms of the jobs that have been on their platform. So going back to the legal health check, a lot of people don't know that they need workers' compensation insurance. It's a criminal offense if you don't have it and you have an employee. Professional indemnity insurance, product liability insurance, shareholders agreement, all these different documents, license agreements, things like that. If you don't know what your gaps are, the legal health check is a good starting point to have a look at that. And again, the exclusive offer is if you do go and fill out that legal health check and give your email address, then you'll get the exclusive offer for anyone that's in this meeting today, which is $240 off the legal advice plan. And the legal advice plan is unlimited phone calls on any new legal issue for up to 30 minutes with the Lawpath Legal law firm. And so I regularly talk to anyone that's on the legal advice plan about it can be anything. It doesn't even need to be legal sometimes. A lot of times it's just what's the strategy? What should I do? How do I approach that? Do you know where I should go? Do I need insurance? Do I need this? And so it's just having sometimes a general chat with a lawyer, or it can be also reviewing legal documents for up to those 30 minutes and just getting advice from a lawyer. The other option is if you on the freemium account where you haven't made any payment and you don't have access to any of the documents, you can get $100 off the essentials plan, which gives you access to the legal documents. So you can either click yes right now in the chat and someone will send you a coupon or a link to be able to sign up, or alternatively, you can fill out the legal health check and the same result will happen. You will get that. Now let's get into questions. So we have, I'm Victorian based. I have a company trading under a family trust. And for some reason, every company I engage with are struggling to understand this. They always look up the ABN for the company, which isn't trading, and they get confused. Why is it so hard for people to understand? Now, this is what the problem is, and this is what I don't understand. A lot of accountants create what's called a trading trust. So it's a family trust, and the trustee is a company or an individual, and that is the actual entity that's going into business with people. By doing a trading trust, you have zero asset protection. It is really bad. In fact, it is worse than any other structure, and the accountants just set it up. And I don't know whether they do it up in error or for some kind of tax break, but it makes no logical sense to me at all. I've talked to Pop Tax and Pop Business, which is the accounting firm here. They also have no idea why accountants structure it that way. The reason is that if your trustee company or you as a trustee are entering into business as trustee for your trust, then that means that if the trustee gets sued, the assets of the trust indemnifies the person that you're entering into business with. So they can get all of your assets. If you have a home in your family trust or shares in your family trust related to other companies or trading accounts or crypto or whatever it might be, they are indemnified against all those assets. So the way that you should be structured is it should be your family trust with your corporate trustee being a company, or you as the trustee, and that owning shares in a separate company, which is all on its own. And if you had one more company incorporated, which is the company that's actually entering into business with, then everybody's just entering into business with a normal company. The only difference is that its shareholder is a trust. But that's a significant amount of companies out there. No one would even know or care who the shareholders are of the business they're entering into business with. So I think you have what's called a trading trust, and it's not a good structure, and I don't recommend it at all. And it definitely causes confusion. What the benefits of a family trust setup for a company? What's the benefit of a family trust setup? So when we talk about family trust, we're normally saying that the shareholder of your company is the trust, or it's the trustee of the trust. The benefit is that if you're married and you want to have kids and you want to take maternity leave or paternity leave, you might be in a circumstance where you're running your business and you might want to put your family trust as the shareholder. What that means is if the family trust is the shareholder, 1 year, one of the spouses could take maternity leave, and that family trust could distribute the income to the person on mat leave. And because they have no other income, they might have a lower tax bracket than you, who's getting paid from the company. And then the next year, because you actually do 24 months of maternity and paternity leave, then the next year you could be in a circumstance where you switch it around. But in short, what it does is it allows you to distribute the income from your business so that it's not all just going to you as the director, or it's not just going to you as a shareholder. The money and the profits from the business can be distributed between different people. So you're falling in the lower tax bracket and paying less tax on the money that you're receiving as a family generally. It also gives asset protection. So if it's just a shareholder of the company, the shares are held on behalf of the trust. Now, though that the trust assets are safe, they're not trading, they're not doing anything. So if you go and forget to renew your insurance and hit a Ferrari and you get sued, you could go bankrupt, but the shares in your business are safe because they're owned by a trust, not by you. So that's another way of asset protection. Are restraint clauses enforceable by law for people that bypass their contract? General principle is that a restraint clause is always enforceable unless it's found unenforceable. So a lot of people say, oh, it's not enforceable. That's not true. Courts are more likely to find them enforceable these days. The reality, though, is that a lot of people actually don't bring it to court because it's so costly to enforce. And the reason it's costly to enforce is that most of the time people will have a restraint to trade clause that allows them to get an injunction. And to get an injunction, you need to file in your state Supreme Court. The minute you have to file in your state Supreme Court, you're paying $2,000 to $3,000 filing fee. You have to have a barrister, you have to have a solicitor. It becomes 25 grand without blinking. And therefore it's more about whether it actually makes sense to actually enforce it. That's what becomes more relevant. But whether it's enforceable, yes, it can be. It definitely, if it's, so the three elements are just geographical location. Is that restrictive enough? It has to protect a business's legitimate interest. So if it's too broad, it's going to be possibly against public policy or possibly unenforceable. The length of time, again, it can't be too long. It has to be a reasonable period of time to protect the interests. And what is the restraint? Is it a restraint from acting in software development in Australia? Well, that's going to be obviously way too broad. But if it's acting in software development for a Lawpath or for a legal platform in Australia, that might be more to protect a legitimate interest. So I work on the basis that it is enforceable unless you get legal advice that says it's not. If you have a corporate trust, does trust information change between states and territories? The answer to that is yes. Every state's different. Some have stamp duty requirements, some don't. Trust laws can vary, and it's based on common law, which is cases, as opposed to normal Corporations Act, which is federal. If you have a corporate trust, in the event that a third party sues the individual and that individual is a director of the trust, will the assets in the accounts also affect a loan? Not actually sure what that means. But essentially, if you have assets in a trust, those aren't owned by you. So if something happens to you, it doesn't matter because you don't own them. So even though you're the trustee of that trust, and even though you're the appointer of that trust, the assets of the trust are not yours, and they don't become yours until you declare them to be yours by way of a distribution. Otherwise, it's an asset that's protected because it's not in your name, it's in the trust's name. We've got to start wrapping up. We have talked quite a bit on branding or on trust, but we have some branding questions I'll try to have a look at. What if you are copying a picture? So that's pure copyright infringement. So I've had a client sued. They've grabbed a website or grabbed a picture off of the internet, put it up on their Facebook page as part of their advertisement. They were sued for $28,000 for copyright infringement. And that's blatant copyright infringement. So a picture definitely is protected by copyright. How do you deal with overseas companies who insist you apply their jurisdiction to a contract? Generally speaking, there's something called the New York Convention. There's 153 countries that signed that convention. You can just Google it. It's called the New York Convention on the Foreign Recognition and Enforcement of Arbitration Awards, 1958. Essentially what it says is that parties can agree to choose their own jurisdiction, parties can agree to choose their own law, and it's going to be resolved by way of arbitration instead of court. Now, if someone insists on their law, I would normally try to argue that an arbitration clause should be inserted. The applicable law should be mutually inconvenient to both parties, and the place for the arbitration should be mutually inconvenient. If they still say it should be their law, then I would say, well, how about whoever brings the proceedings, whoever is in breach, the plaintiff is allowed to bring it under their own law, whereas the plaintiff has to sue in the defendant's location. So there's different ways to do that, trying to work out if someone's going to sue someone, then they got to sue it in where the defendant's based, or if someone's going to sue, it's where the plaintiff is based in their law. So you can work around that a little bit, but there's different ways to get around that. Is the R&D tax incentive retrospective if you start a startup a few years before going incorporated? No, it's not. You had to have it incorporated, and it only applies for work actually done while the company was incorporated and having records of it. What if someone leaves inside their notice period, walks out for no good reason? Do you have to pay them for work that they did up to that point? Yes. You have to pay people for every day that they work. That's the national employment standard. There's no right of set off. You don't have a right to not pay someone a day of work. And that's why it's so important that if you know it's not working out, you were to dismiss them. And that's why it's so important that if you don't know what someone's actually doing, you properly supervise them and make sure that they're uploading their work so you know what they're doing. Because it is fairly common where someone will hire someone, not monitor them, and then 4 months later find out that they've actually been doing nothing and saying they were in meetings, but they're actually out shopping. So that's the importance of monitoring them, having a system where you can track their hours, see their work. There's different software platforms out there, so you can have timesheets for your staff and see what they're doing. What's the best way to offer something for loyal employees that doesn't cost the earth when you aren't making profits? Well, shares are certainly something that they would be very interested in. Having part ownership, bonus, a share of the profits, things like that. But I think that's about it. I'll do 2 more questions and then we'll wrap it up. We've gone over. Do you have a lawyer that's based in Victoria or Melbourne? So Lawpath has two things. One is a marketplace where there's third-party lawyers who quote on jobs. There are various law firms that are in Victoria. The other one is Lawpath Legal, which is actually the lawyers on the legal advice plan. We're all based in Sydney. I have an office in South Yarra in Melbourne. My practicing certificate for the last 5 years was in Victoria as well. And I regularly appear in courts in Victoria, but the Victorian laws and all the courts now have online court, and there's no requirement to be there in person, whereas New South Wales does not. So I've relocated back to New South Wales. So I can attend a court here, but I can attend a court in Victoria as well online, because that's now where all the court is. And does guess I'll just try that one here. What are the fees involved for the legal documents to be done by yourself or on our behalf regarding IP trust setup licensing? And ongoing support in regarding my legal matters. So that would probably be twofold. The ongoing support would be the legal advice plan. And that's where you can talk to a lawyer unlimited for up to 30 minutes on any new legal issue. And then the trust setup, depending on what state it is, it's normally about $600 to get a lawyer to set up a trust. You then have to pay stamp duty. So if you're in New South Wales, it's around 500. If you're in Victoria, it's 200. Queensland and WA, there is no stamp duty that I'm aware of. And then creating, so that's to create the trust deed and to set it up. So that's essentially what the setup costs are. But I think that's about it. I'll pass it back to Angela.
Thank you so much for joining, everyone. For those that asked whether was going to be, sorry, the webinar recorded, it is going to be recorded, and we'll be sending out link to your emails. So please just have a look for that. And we do have many of these webinars coming in the upcoming weeks. If you just have a look at our social media, we do any webinars that Lawpath will be hosting, so you're more than welcome to join that. But as for today, thank you for attending and thank you for all the wonderful questions. Hopefully we'll see you guys in our next webinar as well.
See ya. Thanks for joining.